Paul Managrasso over at CFOAttorney.com, and I'm your host for this week's Wine Wednesday. Have you ever picked up a bottle that says Texas wine and wonder how much of it's actually from Texas grapes? The law actually draws a pretty sharp line here. If you cross it, you can be risking a license and your reputation. Under federal law, the Alcohol and Tobacco Tax and Trade Bureau, for short the TTB, requires proper labeling of wine, including sources of grapes, appellations, things of that nature. Under Texas rules, for an AVA or a county designation, you have to have a high percentage of grapes grown in that area. For example, county designations require 75% of the grapes to come from within that county. The remaining 25% can come from anywhere else within Texas. The state also requires product registration. Under Texas Administrative Code Section 45.5, no wine can be sold or shipped in Texas without a certificate of product registration. And for that, you need a certificate of label approval, a COLA, from the TTB or some other documentation. Practical risks. Mislabeling can lead to product registration rejection in Texas, enforcement action by the TABC, the Texas Alcohol Beverage Commission, or reputational damage. Also, if private labeling or blending out of state grapes, you need to ensure you do not claim Texas or Texas AVA unless you meet the appropriate thresholds. Takeaway. Labeling is more than marketing, it's compliance. If your bottle says Texas wine, make sure you've got the paperwork to back it up if somebody ever asks for it. Now, if you're a Texas winery or thinking of having one, and you want someone who speaks law and wine, again, I'm Paul Managrasso. Let's review your label plans before your next bottling to keep you safe and compliant. Thanks very much. Until next time.